here, except these unique ones that I've just discussed. Your will, it's not a will. It's a certified copy of the will accepted by the master, okay? And so I can continue. Your causa of your sectional title is now going to be exactly the same as your conventional deed. Can you see how you must marry your sectional titles and your conventional deeds? Except that that you've got prescribed forms, there should be no problem with the opening of the sectional title scheme. When I look at mortgage bonds for sectional titles, guys, they will not ask you to draft a mortgage bond. Why not? Because you've got prescribed form Z. You're just going to rewrite prescribed form Z. They can ask you to describe the transfer, the mortgagor. Yes, but that's the same as the conventional deed. They can ask you to draft the mortgagee, which is the same as the conventional deeds. And they can ask you the difference in your first paper, which they love. This question comes up so often in the orals. What is the difference between a conventional mortgage bond and a sectional mortgage bond? My colleague says property description, and that's the question that's the answer that we get. And we say, is that all? And he says, yes, that's all I can think of. No, the one has a prescribed form, the other one hasn't got a prescribed form. The one is executed before the Registrar of Deeds, the other one is executed before the conveyancer. The one's conditions are in the mortgage bond, the other one is contained in an annexure. So there's 8 marks. There's 8 marks. So once again, a question that also comes up, I want to mortgage my section and my exclusive use area and my stand. How do I go about doing this? I go to, by way of an example, I go to a bank and I say, I want to borrow 100,000 rand, please. No, that's too little. I want to borrow $1 million rand. And they say, Alan, what security have you got? I say, well, I've got a sectional title unit, an exclusive use area, and I've got a stand. They say, we'll take that as security. How are you going to get a mortgage bond registered over that to secure that debt in favor of Absa Bank? Have you thought about that? Can I register a mortgage bond over sections, exclusive use areas, and conventional deed? No, not in one mortgage bond. There'll have to be 2 mortgage bonds, but how can there now be 2 mortgage bonds for the same debt, etc.? So what you will do is you will register either a sectional bond in respect of that or a conventional bond, and the other bond will what we call is a collateral bond. A collateral bond in terms of prescribed form KK that you have got in your Deeds Registries Act, and in terms of the Sectional Title Act, there is a prescribed form for a collateral bond as well. There wasn't in the past. It was brought in, I think, in 2011. They brought in the prescribed forms for the surety and collateral sectional mortgage bonds as well. So keep that in mind when looking at bonds. But I say once again, they're not going to ask you to draft a bond. It will be more theory with regard to the mortgage bonds. So now we've opened our sectional title register. We've transferred our first section. That's section 11 and section 12. Section 13, I'm not going to worry about. Section 14 of our Sectional Title Act is the amendment of a sectional plan. Section 14, 1, 2, 3, 4, and 5. That is when there's an error on the sectional plan and you're substituting that sectional plan. Yes, they can perhaps ask you, but I see the Act has just been amended. Previously, the conference said you have to draw an application. The Chief Registrar in Circular 3 of 2020 said, no, that conference resolution created law, no application is necessary. So there can't be a question on 14.123b, 14.123, 4, and 5. Section 14.6, they can ask you something about Section 14.6. This is when all the sections are owned by the developer, and the developer wants to collapse the scheme. He can collapse the scheme in terms of Section 14.6, and Section 14.6 specifically tells you how to go about it, and then the conventional title deed is revived by virtue of an endorsement. So they can ask you perhaps to prepare this application in terms of Section 14.6 to cancel or collapse a sectional title scheme. Section 14.8 is the cancellation of a sectional plan by order of court. They cannot ask you anything on that. So just know that the different ways of collapsing a scheme is section 14.6, section 14.8, section 17 of our Sectional Title Schemes Management Act, where section 17 of our Sectional Titles Act, where we sell all the common property, or section 17 of our Sectional Title Management Act, read together with section 49 of our Sectional Title Act. Those are the ways to collapse a sectional title scheme. But once again, that's a bit of a theory. They've never, and I'm scared about this, they've never asked you anything on the collapsing of a sectional title scheme. Never. If you read Gabi's notes or you read my book, I've got a short summary of how to collapse a sectional title scheme. Just look at that for purposes of this exam, because as I said, that is something new. I hope Anton is listening to me. Maybe he is listening to me around the corner. Maybe there is going to be something on the collapsing of a sectional title scheme. Section 15, that is once again just the transfer of the property and how it is conveyed. Section 16, 17 of the Sectional Title Act. Yes, section 17 I'm looking at, because there it is the sale or the lease of a portion of the common property and the reversion thereof back to the land register. So I would look at specifically section 1 read together with section 17.5 if I'm going for the book prize, okay? But this is very intricate. Now I can tell you, once again, not being facetious, but certain of the examiners don't know how to apply section 17 because it's very, very intricate. Section 18 I'm not looking at. Section 19 I'm not looking at. That is the section 19 is the expropriation of common property. They can't ask you anything about that. Section 20 I'm not looking at. 21 to 23, very important. The subdivision and consolidation of sections. So the subdivision of a section and the consolidation. What can they ask you there? Draft the application. Tell me what supporting documents must be lodged. Guys, in my book, I've taken you and I've said, this is the prescribed form. And I usually say O, it's O. Most of it is O. Like the other one was T, this one is O. So remember O, you go to O, you rewrite O, but you qualify O because it has footnotes for the subdivision and the consolidation. They might ask you, must it be contiguous to one another to consolidate? No, it doesn't have to be. Look at the supporting documents that have to be lodged. So once again, section 21 to 23, subdivision and consolidation. Section 24, once again, form O. So you're going to use O again. And you're going to, and then they might ask you, what is the position with regard to the mortgage bonds? Must you lodge the bonds? Must you lodge the consents? My time just doesn't permit me to explain this to you, but I've tried as far as possible to categorize and stipulate what documents you're going to lodge. When do you have to lodge the bondholders' consents? Is all the bondholders' consents necessary, or is it just a consent, not a consent, a certificate by the conveyancer? So look, if I have to do the exams, I'm going to spot section 24. It comes up very often because it's happened so often now in practice, ladies and gentlemen, that specifically in Gauteng, where we have 19,000 what we call duets, and a person staying in a duet believes that he's the owner of the land and he can build on a garage and he can close his patio, and then when he wants to sell it, the financial institutions come out and say, this garage and that lapa and that swimming pool, where is this on the plan? No, it's not on the plan. You have to get new building plans, you have to get occupational certificates, you have to get new sectional plans, and you have to extend the boundaries of your section if you've encroached onto the common property. So the extension of a section in terms of section 24, very important. Application and what documents must be lodged. Section 26, the extension of the common property. They cannot ask you in a long paper this. They can only ask you something in the theory. that if you want to extend the common property, the body corporate must acquire the property. And now, if the body corporate acquires the property, how are you going to describe the body corporate? Specifically, section 36(1). I don't know if section 36(1) has now been repealed by section 2(1) of the Sectional Title Act, but it tells you how to describe a body corporate, okay? So you must know how to describe a body corporate. And then it is incorporated into the sectional title scheme as such. The extension of a scheme. Now, I didn't touch on this when I opened the scheme, but if I'm reserving a right to extend my scheme, there's certain additional documents that I must lodge with the Registrar of Deeds. And you will see that's all set out in terms of section 25(2) A, B, C, and E. You must memorize those documents because it is the terrain plan, 25 A and B, it is what material is going to be used, how the participation quotas are going to be affected, etc., etc. So with the extension of a scheme, they can ask you what documents must be lodged to exercise your real right of extension or convert your real right of extension. That is something that you must also know. And look at specifically section 25(9), for which there's once again a prescribed form. This has not been asked. The conversion of a real right of extension into a sectional title, and draft the application and say what supporting documents must be lodged. Spot this, 25(9), spot this. Once again, I get this feeling, okay? So that's section 25. Section 26 we've already touched on. Section 27, don't look at that. Oh, sorry, section 27 is exclusive use areas. Theory. How do you create exclusive use areas? How does the developer create it? How does the body corporate create it? So section 27, NB. Section 28, no. Section 29, no. Section 30, no. Section 31, no. Section 32, no. Section 33, no. Section 34, NB. This is when the developer is selling the scheme, all right, title and interest in the scheme. You must just know there's a prescribed form H with a footnote, and you will say he's selling all the right title and interest in the scheme comprising of to so-and-so, and it's comprising of. Then you have to repeat every section. Now, this scheme can consist of 50 sections. You're not going to write out all 50 sections. You're going to write out section 1, and you're going to say, I repeat section 2, section 3, section 4, section 5, as I did with section 1. But that form H tells you that. Right, so that is section 34. The rest of the Sectional Title Act, no, you stop there. So what am I spotting in my Sectional Title Act? I'm spotting, obviously, the opening of a sectional title register, the power of attorney, if it's an estate or whatever the case may be, either my consolidation, subdivision, or extension of a section, and my section 25 conversion, and my section 34 transferring, and theory, my exclusive use areas in terms of section 27. Sectional mortgage bonds, there are my prescribed forms. As I said, there are prescribed forms. They're not going to ask me. They might ask you to, as I gave you the example of when are you going to use it as a surety sectional mortgage bond or collateral mortgage bond, but you've got your prescribed forms. Exclusive use areas, the session thereof, they're not going to ask you to draft a session because that is notarial. That's a notarial document that you're going to do in your notarial exam. And unfortunately, in the notarial exam, you don't get this book. But it's an agreement. And I said to my colleagues, if you're going to do the notarial exam, guys, the notarial exam, if you've got a good working knowledge of conveyancing, notarial should be a walk in the park. Because if you can draft an agreement, you can draft any notarial document. Because there's no prescribed forms. No prescribed forms whatsoever. Conversion of a share block into a sectional title, guys. If you're going for the book prize, I would tell you to study it. At this point in time, if you don't know it, I'm not going to ask you to study it now. Statement of an account, and Anton said that you were right in the beginning. Yes, finances, finances, finances. And believe me, I'm sure there's going to be a question on transfer duty. And the transfer duty question is always linked with a statement of an account, because you must account for it in your statement of an account. So, and we've already said, and Anton reiterated this, and it will be part of the memorandum, that if you can balance your statement of account, hallelujah for you, and wonderful. But have you got time to sit and calculate and add up and minus? If you just got all your debits and credits correct, don't worry about finalizing your statement of an account. If you can, hallelujah for you, wonderful. But you might get the book prize then. But if you're going for the good book prize, do it. Okay. Right, Chief Registrar Circulars. I say all the relevant Chief Registrar Circulars must be perused. I've already, in this document that I've given you, I've already told you which Chief Registrar Circulars are important. And I'm going to reiterate and I'm going to repeat them when I go through the syllabus again. It's impossible for you. Remember, the first Chief Registrar Circular was issued in 1940. And it's now 2020. And there must be over 1,000 Chief Registrar Circulars, and many of them have been repealed. You won't be able to even look at them. Jutta has got a whole book on Chief Registrar Circulars. So once again, no, the relevant Chief Registrar Circulars, yes, which we're going to touch on. Conference resolutions. You're going to ask me which conference resolutions. We've sent you electronically. We've sent you 2019, 2018, 2017, up until 2013. That's a lot. I'm not going to say to you, don't go through them, because they have now actually crystallized the practice. So there might be short questions on the conference resolutions, but you know, you can't go back to 1938. The first conference resolution was taken in 1938. I can show you how thick the book is on conference resolutions. Somebody said to me the other day, no, you can't see this. You can't see this. He said, if I study all the conference resolutions, will I pass the exams? I said, no. Because those conference resolutions are not going to let you pass the exam. It's good to have it in practice, but it's not going to make you pass the exam. Unless you know everything else. So conference resolutions, look at the last 3 years conference resolutions. Deeds practice manuals, guys, you can draw a line through that. These practice manuals have now been stopped by the Chief Registrar of Deeds. She says, I think it was Jutta was making money out of the deeds office, therefore she ceased to give them the right to sell the deeds practice manuals. It was a wonderful document, because actually it was the Bible of the deeds office, and you could argue with the examiners on their Bible. Now you haven't got a Bible anymore. Now you have to, and sometimes you take West, and sometimes it works, and sometimes it doesn't work. It depends who likes West and who doesn't like West. So, and that's why I always say, ladies and gentlemen, if you look at my book, I say for every statement I make in that book, I try and substantiate it with conference resolutions, Chief Registrar Circular. Don't go and say, Alan West said. Say that conference resolution, that Chief Registrar Circular, or that court case says, and then you're on a winning wicket, okay? Somebody asked guarantees, and I think they asked Anton that in the first day. Must I know about guarantees? You know, if I'm registering a mortgage bond and there's a cancellation, what guarantees will I be able to, will I have to prepare this guarantee? Guys, I don't know. I'm not. It is part of the syllabus. It is part of finances. You must know it, because if you're going to be a conveyancer, you must know what guarantees, and you must know what must be contained in the guarantees. Okay. Right. The examination criteria, I'm not going to go through, because Anton said that is in the melting pot at this point in time. When we get finality on this, Anton will give it to us in writing. I will be sending it through to Lead, and I'll ask Lead to send it to everybody that has enrolled for this webinar. So I promise you, as soon as I've got any finality on this from Anton, I will send it through to Lead to send through to you. Yes. Right. Then we come now to the syllabus. The Administration of Estates Act. Guys, and here I want to break it down again. And I know what I'm doing is very dangerous now. The Administration of Estates Act, I can't study Section 1, if you understand. That's the definitions. Section 3512, what can they ask me? They can ask me something about massing and ideation in terms of Section 37, and then the 42.1 and 42.2 certificates. Section 80 of the Administration of Estates Act, NB. And how do I study Section 80? I study it together with the Children's Act, specifically Section 18 of the Children's Act. Okay, a minor below 250,000, over 250,000. Somebody that has been placed under curatorship. What is the position there? Section 80 tells you that. So Section 80, if there's one section here that I'm going to study very well, it's Section 80. The Advertising on Roads and Ribbons Development Act. It's two sections. Section 1 is definitions. It tells you what the definition is of a building restriction road. It's a main road or a road which has been proclaimed as a building restriction road. And then Section 11 tells you that there are certain restrictions against property that is within a certain distance from a building restriction road, that you're not allowed to subdivide it if it's within a certain, you're not allowed to transfer it to more than one person, etc., etc. I would just look at Section 11. And if I say Section 11, look at Section 11.4, which is one that affects the conveyancer as such. The Agricultural Holdings Act, you draw a line through that, not for the oral. If you're in Gauteng, they're going to ask you, and I'll never forget, one of the examiners always asks in the oral, how do you describe an agricultural holding in your property description? They're not going to ask you that now because this is a national exam, and this is only applicable to the Old Transvaal. The Alienation of Land Act, we've done that. Okay, we've done that thoroughly, and we said, remember, Section 1, and then Section 10 and 11, well, Section 2 and 3 as well, Section 10 and 11, Section 20, NB together with the two prescribed forms, Section 25 and Section 29, capital A. The Birth Death Registration Act, Section 23 to 26. I want you to study this in conjunction with Section 93. This is the change of name of natural persons. Remember, if a woman marries a man, she has the right to assume his name, etc., etc. Section 93 is not obligatory there. It is not preemptory. It can happen. If I want to change my surname, I have to do it in terms. If I marry in terms of Muslim rights, the wife, irrespective of that the Muslim rights is not recognized in South Africa, the Muslim wife can assume the name of the husband without going through the procedure of advertising. The Black Communities Development Act. That act has been repealed except for sections 53 to 57B, and those are properties that are still leasehold. This is a very contentious act. And except that they can ask something in the oral, they will not ask something in this exam. The Children's Act, I've already said, Section 18, read together with Section 80 of the Administration of Estates Act. The Civil Union Act, this questions come up often. The definition of a civil union marriage. What is the criteria for a civil union marriage? But everything here is set out in Chief Registrar Circular 1 of 2007. So if you know Chief Registrar Circular 1 of 2007, specifically the description of persons that have entered into a civil union. Somebody, I don't know who of you follow social media. There's a group called Cactus and the Actus. It sounds crude, but it means cactus in the actus. So cactus in the actus, and somebody asked, where do I find out how to describe parties who are married in terms of a civil union? There's a Chief Registrar Circular. So for things like this, just go to the Chief Registrar Circulars, and you will find it. Or go, what I do find is people don't do research anymore. They want answers just flying out of the air. The Closed Corporation Act, I'm not going to study that because it's been repealed in any case, okay? They might ask you, can you change a company into a closed corporation? You could. It could have happened prior to 1 May 2011, but after that it cannot happen. You can convert a closed corporation now into a company that is, and here I want you to look at Chief Registrar Circular 28 of 2013. I'm going to get back to that Chief Registrar Circular now. The Collective Investment Schemes Act, this is the participation mortgage bonds. There's a Chief Registrar Circular on that. And guys, it is a 2002 Chief Registrar Circular. Forgive me, I haven't got the number, but if you've got my book, go to the 2002 circulars, it's there. Now, the Companies Act 71, they say the entire act, that's not true anymore. They've broken that down into sections, but I want to break it down further. I want to tell you that Companies Act, if you study Chief Registrar Circular 28 of 2013 and sections, I think it's 40 to 45 of the Companies Act, you're safe. Javi Leroux has a wonderful note that he said, this is how the new Companies Act affects conveyancing. It is a wonderful note. If you've got that, please study that, okay? The Constitution of the Republic of South Africa, I believe this is the most wonderful piece of legislation, but I'm not going to study it for the exams. So, at this point in time, no, even if it's only 2 sections, I don't think. The Consumer Protection Act, they've broken that down into sections again. Look at your new syllabus. It is in your new syllabus how it has been broken down. The Donation Tax Act, all that you must know there is what is the going rate of donation tax and what are the exemptions. Okay? And is it 25% now? And the first 100,000 is exempt, and donations between spouses is also exempt. So once again there. The Estate Agent Act, only section 32, but the Estate Agents Act, I think that act is going to be repealed, or it has been repealed, or it's in the process of being repealed by the practitioners, that Practitioners Act now. But section 32 just says that they must have a trust account. The Expropriation Act, that act is in the process of being repealed. I'm not going to study that for the exams. FICA has been asked in the past, what are the duties of what do we call the institution, a FICA institution, there's a specific word, and how do you FICA a company, how do you FICA a natural person, how do you FICA a trust, how do you FICA a foreign company? So those are the aspects that you must look at in any case. Formalities in respect of leases of land, 18 of 1969. Only one section, they say the entire act, but it's only one section. And that section is hier gaat voorkoop. So if you know the hier gaat voorkoop and the rule of knowledge, and that any lease agreement for longer than 10 years will be immovable property provided it has been registered, otherwise it stays movable. It's immovable unless it has been registered. The Housing Consumer Protection Act, questions have been asked on that in the past. So if you look at your old exam papers, just look, because all 3 of those sections have been asked. The Immovable Property Modification Act, all that I want you to know under that act is that a fideicommission or a successive fideicommission is only valid and binding up until the 3rd generation, or the 2nd set of fideicommissary. That's section 6. So all that you must know is that a successive fideicommission is only valid and binding up to the 2nd set of fideicommissory heirs. Thereafter, it vests free from it. The Immigration Act. Here they ask to differentiate between a foreigner and an illegal foreigner, definition. And then they ask, can a foreigner acquire property in the Republic of South Africa? A foreigner can buy the whole of the Republic of South Africa if he's legally in South Africa. If you're sitting in Nigeria and you've got the money, you can buy the whole of South Africa, but you cannot occupy it unless you, so there's no restriction on a foreigner. However, Section 42 places a restriction on anybody abetting or assisting an illegal foreigner from acquiring property in South Africa. And there's even a sanction placed in terms of Section 49 on anybody assisting or abetting an illegal foreigner. An illegal foreigner is somebody in South Africa that's illegally in South Africa. The Income Tax Act, the most important section that I'm looking at there is Section 35A. Section 35A, I don't think it has been asked in the exams, if I'm not mistaken. That is the duty on a conveyancer when transferring property that belongs to a non-resident. Who is a non-resident? You will find the definition of a non-resident in the Income Tax Act. There's certain periods of time that you have to be in South Africa to be regarded, or out of South Africa to be regarded as a non-resident. And if you are non-resident, the conveyancer, if you're a natural person, must retain 7.5%. If you're a company or closed corporation or whatever, you must retain 10%. And if you're a trust, you must retain 15%. And that must be paid over to SARS. Alternatively, if you don't do that, the conveyancer can be held liable in his personal capacity. That's why I say this is one of the favorite questions in the oral. What are your duties as a conveyancer in terms of Section 35A? Because, guys, if you are a conveyancer and you do not know this, you can come off second best. The Insolvency Act. There, once again, I've already tried when I did insolvencies to discuss rehabilitation, and specifically Section 127A of the Insolvency Act, read together with Section 25. Look at the provisions of Section 80, Section 80, Section 80bis, Section 81 and 82. That is when the trustee is selling property with whose permission it must be sold, okay? Interstate Succession Act, NB. But it's one section. It's 11, 11A, 11B, 11C, 11D, 11E, and then 12, 13, 14, 15, 16. So that is a very important, and I will have a good working knowledge of the Interstate Succession Act if I go into the exams. The Land Survey Act, guys, I'm not going to study that for the exams. The Matrimonial Property Act, Section 15, NB, the whole of Section 15. The Recognition of Customary Marriages Act, NB, but I'm not going to study the Act. I'm going to study Chief Registrar Circular 27 of 2013. The Removal of Restrictions Act has been repealed, so take it out. Share Block Control Act, I'm not going to study that. The Subdivision of Agricultural Land Act, NB, for your first paper once again. What servitudes can be registered without the minister's consent? Section 6, capital A. Study that. High Court Rule 63 and the Hague Convention, NB. And I always remember, when I think of High Court Rule 63, I think of the Big Five. And that's not the elephant and the rhino. It is the 5 countries that you have to know that it can be it can be authenticated before a notary. Otherwise, the ambassador of the country or whatever the case may be. Transfer Duty Act, we've already touched on. Trust Property Control Act, they love asking the definition of a trust. And can a trust acquire property before the trustees have been issued with letters of authority? Look at Section 4, look at Section 6. The Value Added Tax Act. There, once again, we've touched on that. Is transfer duty payable? Is VAT payable? If VAT is payable, at what rate is it payable? So you must know that for purposes of the value added tax. Provincial ordinances and regulations, they cannot ask you that. SPLUMA, they cannot ask you anything on the bylaws. They can ask you something on Section 53. I fear to say that I don't know what they can ask you on SPLUMA, because it is an umbrella act and the regulations is the bylaw. So I just look at Section 53 as such. Now, these 5 acts that we're looking at here, the Less Formal Township Establishment Act, repealed. Property Timeshare Act, I'm not going to look at. Restitution of Land Rights Act, I'm not going to look at. Maybe something on the Upgrading of Land Tenure Act, also called ULTRA. What informal rights have been upgraded? The National Credit Act, they have asked you questions on that. The Extension of Security of Tenure Act, I won't study that. The Retirement Act, I'm not going to study that. The rest, guys, as I said, the conference resolution circulars, we've already touched on that. So that is the syllabus. And I know it is an absolute mouthful. But if you once again go through this guidelines how to prepare for the examination, and you work through that, and you can prepare you can identify and prepare these documents, and you can go to old exam papers, and you can answer those old exam papers. Don't try and compare it with your memorandum, because can I say to you, and once again, some memorandums are incorrect. No names, no pattern. Some memorandums are incorrect, and you are studying incorrect things. So, and this is an invitation. If you are not sure, phone me, email me, and I will tell you you're on the right track or you're not on the right track. You know what? I've even said to candidates here in Pretoria that failed the exam, they come to me and they say to me, you know, my husband thinks I'm a dumb idiot. And I say, why? No, I've failed the exam 5 times. And I say, you know what? Your invitation is start working out old exam papers, and during your lunchtime, you come to me and I'll mark it. Not one of those candidates have come to me. Not one candidate. Maybe she thinks I'm going to think she's a dumb idiot. But be that as it may. Guys, our time is almost up, but I have 10 minutes still for questions and answers. So I am now going to ask you once again to ask a few questions and answer it, and I'll see if I can answer it. Any questions from your side?
Hi, Mr. West. How are you?
Yeah. First, your name. I'm trying to put the face by the name.
Oh, my name is Zamuxolo Matungandaba. Zama, for short.
We haven't met each other, have we?
No, we have. No, we actually have. But some years ago.
Okay.
Yes, when I was doing law school.
I'd never forget a pretty woman's face. Remember that, eh?
Yes, Mr. West. So I just wanted to ask you, when it comes to particularly with describing of civil union parties, right? Because you know that with the civil union, it can either be solemnized by way of marriage or by way of, you know, there's different ways. Yes. So now I came across a question where that wasn't specified, you know. So should we just go with the partnership in that case?
It was specified. Look, if you're entering into a civil union, you have one of 2 options, and I see in terms of Home Affairs now, you have to declare before the marriage officer whether it is a partnership or whether it's a marriage. If it's a marriage, if your question says they entered into a marriage, it is just like any other heterosexual marriage. It is A and B married in community of property, or it's A identity number married out of community of property. If they said they entered into a civil partnership, then it is a partnership, and then it is not, it is in community of property, but it's a partnership which has the effect of in community of property in terms of the Civil Union Act. So the question will have to categorically say they've, let us now say the examiners said they entered into a civil union. They didn't say it's a marriage. They didn't say it's a partnership. You know what? They regard it as a marriage, and you make a little star and you say, you didn't say what it was. I regarded this as a marriage and not a civil partnership. But if the word partnership is there, then you know it is a partnership and you must describe it differently. Does that answer? Are you gone?
Yes, I'll make sure to read the question very well.
Just read the question again, and if there is any confusion there, phone me.
Okay, thank you. Thank you.
All right. Anybody else?
Meneer West, jammer, dis Nathan van Sail. Ek wil net graag hoor, kan jy my hoor?
Ek hoor jou Nathan, wil jy nie
Wel-
graag Engels praat nie, want anders gaan die ander mense jou nie verstaan nie.
Okay, Mr. West. The registrar conference resolutions and so forth, they obviously, they're quite a lot, even if they are only specified, some of them. Do you need to say 427 of 18 or whatever? Will it be good enough? Okay, thank goodness. Okay.
No, Mr.
Okay.
Is it Mr. Van Sail? What?
That's it, yeah.
You never, if they ask for authority and you can say a conference resolution or a chief registrar circular, remember, the examiners don't even know this. Everybody thinks I'm clever, but it's because I repeat this on and I know the conference resolutions, etc. It's not expected of you to quote any number of any conference resolution or any court case in full. If you know there's a court case, hallelujah, and you will impress the examiners to no end. But no, you don't have to refer to the conference resolution or chief registrar circular by number.
Thank you.
Anything else? Guys, having gone through the syllabus now, and you studied what was supposed to be studied, take the last, and I asked Anton, how many exam papers, and this question gets asked to him, how many exam papers? And he says, as many as possible. But if you take the last 5 years exam papers, believe me, that's 10 exam papers. That everything should have been covered by that, except obviously SPLUMA or the Sectional Title Schemes Management Act or the CSOS Act, the new acts that have come in very lately, but the rest has all been covered. I can't, yes, examiners want to get new questions. Where will they get new questions from? Maybe the latest conference resolutions of 2019 and 2018, possibly. But as I said, if you take the last 5 years papers and you can start now and you can start answering those papers and the extending clauses in that, you're not going to have a problem because then you can do it. If you can do one extending clause, you can do any extending clause.
Just look at the last one. There's no contents.
Anton has just walked in and said to me, tell them to look at the last 5 years examination papers and the last few years conference resolutions. So there's a tip. My colleague's laughing. She says, what tip is that? But if you can answer those papers, you're going to pass the exam. That's as easy as that. Here's a question. Guys, and usually, when I don't do this at Zoom, I ask more questions. And the one guy in front at some time ago, he put up his hand and he said, sir, I haven't got any questions, but all that I want to ask you is, will you pray for us? And yes, I will pray for you. You are in my thoughts. I want to see you in the deeds office, executing deeds and riding a Porsche. So guys, all the best, and we all want you to pass the exam, and it will be a happy day if we can have 100% pass rate. But believe me, that's not going to happen. All the best. the orals, etc. I think Anton is just going to elaborate on that a bit. So I'm going to hand over to Anton now. I also want you then, obviously, if you have any questions, uncertainty, please pose your questions to him. He will try and answer it as comprehensively as possible. He's not going to tell you what's in the exam paper because I can without hesitation tell you that the exam paper hasn't been prepared yet. So, but I'm sure he will be able to give you good guidance. Thank you so much once again for attending, and I'm handing over to Anton. Anton, thank you so much. Can I just leave it? Yes, you can.